The fact that Jacob Zuma, former president, is pursuing a private prosecution of state prosecutor Billy Downer. Now, Zuma alleges Downer handed over private medical records to News 24 journalist Karyn Maughan, who they're also suing. It's a matter the NPA has decided not to prosecute. The media house, News 24, says nothing that wasn't available in the public court records was actually published. The SA National Editors Forum believes this is an attempt to intimidate the journalist. Downer is, of course, the lead prosecutor on Zuma's arms deal corruption case, and Zuma has also been trying to get him removed from that case, saying that he is biased, a legal argument that has so far not been successful in the courts. So, could Zuma have grounds on this matter? I'm joined now by advocate Ben Winks, who specialises in media and constitutional law. Advocate, thank you so much for your time. So, Zuma's spokesperson has said that they've got proof that Billy Downer handed over Zuma's private medical records to Karyn Maughan before they were made public and admitted into court. Media 24, they say, well, that doesn't matter because the story was only published after the documents were put into the court record. So, does it matter? Or could Zuma's legal team actually have a case here?
No, it doesn't matter. So there was an archaic rule, decades ago that you could only refer to a document or publish a document that forms part of a court record once it's been referred to in court. That's no longer the case. In fact, coincidentally enough, there was litigation relating to the spy tapes that Zuma had provided to Mokotedi Mshe in order to have this very same prosecution dropped back in 2009, that because the spy tapes formed part of a court record, they were public. So the situation we have now in South Africa under the constitutional dispensation is that all courts are open to the public by default. That means not just the courtroom doors, but the documents that are filed in court as well. Now, if a party wants to have any confidential documents sealed from public view, the onus is on them to bring an application to court to say, I want to file some confidential documents. This is why they're confidential. Can they be placed in a sealed court file which will not be publicly accessible? Well, that's not what happened here. So there's no longer any requirement that a document has to be referred to in court or produced in court. The court file is a public space. It's publicly accessible. And once you file a document, which means as soon as Billy Downer got his hands on it, it's a public document. So there's nothing that prevents him from sharing it with any member of the public, including a journalist. And there's nothing preventing a journalist, obviously, from receiving it and then publishing it. It's a public document.
All right. So the fact that she may have received it before it actually went to court, but held back on publishing it until after it was a matter of public record, that's neither here nor there, you say, these days?
In my view, it's not. The authorities about referring to a document in open court are completely outdated. They've been overtaken by various constitutional court and Supreme Court of Appeal judgments. And what you have is that, when you say it's in court, once it's been served on the other side, it's public. Unless it's subject to an application for confidentiality, then it's public. So unless Downer got it by hook or by crook without it actually being served on him, then it was a public document. And I don't believe that there's any allegation that he stole it from Zuma's attorneys before it was served on him. They're saying that it was served on him and then he shared it, and there's nothing wrong with that.
And the NPA seems to be of that view as well, because they've issued this null prosecute, I think is how you say it. Basically, they're not going to pursue this. So the only avenue left, and you can only do this after you've got this null prosecute decree, is then private prosecution. And this matter is going to go to court, Pietermaritzburg High Court, in October. I wonder if you could explain this private prosecution process. How does it work exactly? Is there a higher or lower bar to show proof? How does it work?
So obviously anybody can bring a civil case against somebody who's wronged them. They crashed into your car, they assaulted you, whatever the case may be. But when you lay a criminal complaint with the police, the state has the first right or the first prerogative to institute a criminal prosecution that could result in a person paying a criminal fine or serving time behind bars. So the state has to assess the criminal complaint, and a prosecutor will decide, once they've received the docket from the SAPS, whether there is enough evidence to secure a successful conviction. If the prosecutor decides that there is not enough evidence, then the prosecutor issues what is known as a nolle prosequi certificate, which is a decision not to prosecute. And once a complainant has that certificate, then they can say, well, the NPA don't think they can prove the case, but I think I can prove the case. So I'm going to institute a private prosecution. And that is what Mr. Zuma is doing here.
Okay. So talk to me about your view on, SANEF is saying, the National Editors Forum, this is an attempt to bully a journalist. Others believe it's an intimidatory tactic aimed at Billy Downer, perhaps both of them. How do you view what they're doing and their motives?
I would have to see a lot more evidence to decide on what their motives are. It may be that they believe wrongly that the law didn't allow Downer to share the information and didn't allow Maughan to receive the information. Maybe they believe that wrongly. I'm not sure. There may be evidence that says they don't realistically believe it. But motive will become important because you can have a claim, including a private prosecution against you, dismissed even without getting to the merits, if it is an abusive court process. And one way to test whether something is an abusive court process is if it's brought for an ulterior motive. But the onus, of course, then rests on Maughan and Downer to prove that it is brought for an ulterior motive. So that might be one strategy that they could employ, is in order to get it dismissed at the outset without even getting into the merits, to show that it's brought for an ulterior purpose. And they would lead all kinds of evidence about the personal dispute between President Zuma and Advocate Downer that has spanned decades now. But that would certainly be, I think, probably the first sight of the battle would be an investigation into whether there was an ulterior motive for this private prosecution.
Thank you so much for explaining that so very clearly and helping me to pronounce it correctly. Nolle prosequi. Right, so now we know what that is. Thank you very much, Advocate Ben Winks. He specialises in media and constitutional law.